Good afternoon, ladies and gentlemen. We're going to get started with our state legislation updates and list of bills that we want to discuss and perhaps take some positions. Want to acknowledge that we do have a packet with some bills. There's also a couple additional bills that Ms. Myhill is getting copies for you that Ms. Wanger is ready to discuss as well, so I want to make sure that everybody has a copy of those. So we'll start, turn it over to you, Ms. Wanger, and tell us what's going on. I know things are getting pretty exciting in Annapolis that time of the year. And,
yeah, it is that time
as always, you look very fresh and collected.
Well, thank you.
So, you know,
After,
all works out.
I think everyone worked all weekend. I think it's been 16 hours, and yeah, it's
You know.
an average session, so it's no big deal. But yeah, so I looked when I was trying to write a header for what is the update of the 2019 session, what sentence could I put beneath that, and I realized we are a third through session already. And I think last week was the House filing deadline and the Senate filing deadline, and so I think when we all get back to Annapolis, we'll see like another 500 bills added to the list, but we have not looked through or processed yet. So, 'tis the season. So what you have before you today is a relatively short list, but there are some additions as a result. The one thing, some things we're interested in, obviously, the public school construction bills are scheduled for hearings. We do not yet have a Kerwin bill, and we're still anticipating that we will be receiving one. My guess is it will be a lengthy document. And again, as I spoke last week, I think it will start to kind of lay out a backbone plan, and potentially moving forward, it would obviously not have some of the detail, state and local cost shares and details about formulas, because those, the plan is to work them out over the spring and summer. And so that kind of larger, very important negotiation to counties will occur outside of this piece of legislation. So we do have a couple bills for you, and then we also have a couple of additions, and we also sent, last night, Amanda sent a packet on the small cells issue. We did not have the text of those pieces of legislation. I mean, this is kind of the tail wags the dog sometime in the legislature when you get a huge dump of legislation, particularly this year. So the print shop ended up being like 3 to 5 days behind the introduction of bills, so we didn't have the text. And we did know that those bills were drafted to a different state article than kind of what we had anticipated before, so we definitely wanted to see them before we provided you a lot of information on them. So you've got that also attached to the package. We can talk about that after we talk about the bills, or you can absorb it, and we can talk about it later. But the House bills are scheduled in the House Economic Matters Committee for the 21st of February. And so when we get there, we'll talk a little bit more about what you own in your packet on that. First piece of legislation, I know that there's been a fair amount of activity even this morning about this issue. It's House Bill 413. Kathleen's been working on this issue, has worked on it for the last couple of years. And we also have Mr. Lantner from the County Attorney's Office to also provide additional detail as needed. So if it's all right with you, I'll turn it over to Kathleen to talk about this bill.
Good afternoon. As Mel mentioned, this is a bill that has been introduced in similar forms before in 2016, 2017. It's a bill that relates to the Maryland Public Information Act. And right now, under the Maryland Public Information Act, if someone makes a complaint about employee misconduct, and there's an investigation or a hearing and a decision about discipline, that is considered all of that is considered a personnel record that is subject to mandatory non-disclosure. It cannot be disclosed by a governmental unit. And what this bill does is it changes that so that there would be a discretionary disclosure by a governmental unit, so that if a complaint like that is made, if there's an investigation, if there's a hearing, if there's a decision, which there would be eventually, the documents related to that would be able to be disclosed by a governmental unit if it was in the public interest. So that's the main piece of the bill. There's a lot of related background. I'm not sure how much detail you'd like to go into. The county executive is not taking a position on the bill. MACO opposes the bill, and in the write-up that's attached to Melanie's memo, started on Circle 2, there's a write-up on MACO's opposition. The primary concern is that although it turns it into a discretionary decision, there's a concern by MACO that that's not really discretion because the MPIA essentially presumes disclosures in the public interest. So MACO would be concerned about what public interest, if any, could overcome that default position in the MPIA that disclosures in the public interest. And then in the write-up, MACO identifies a number of other concerns, and be happy to discuss it further. And Ed Latner has been reviewing the bill and discussing various issues as well.
Mr. Latner, anything you want to add?
No, the only thing I'd add is this would take personnel records or a subclass of personnel records and move them, make them investigatory records. Just realize, although that's a discretionary category, it's not unreviewable discretion, that somebody can go to court and challenge, and the court might decide, no, this should have been released. You as the custodian did not proffer sufficient reasons that it would be against the public interest to not release it. So it's simple when it's in the personnel category, your hands are tied. With your hands not tied come responsibility and discretion, and the responsibility to, exercise that discretion uniformly in a non-discriminatory manner, and it is also subject to review. So you get discretion, but you get review.
And you did say that the county executive took no position. Okay, now Councilmember Reamer.
Thank you, Council President. I appreciate your adding this to the agenda today. I asked that we add it because I have been working for some time on different issues around police policy and police accountability and civilian oversight. And I would like to share just with my colleagues just a little context there. Last year, as we all know, there was a police-involved shooting that a lot of us are concerned about, a lot of public concern, and I began meeting with the NAACP to talk about the issue and what we might do to address it. And the NAACP was asking us to take a look at a civilian oversight board that could review incidents and disciplinary matters and weigh in. And I went through with council staff, Amanda and Bob, and we worked very carefully on legislation, and we ultimately, after a lot of work, concluded that there were some significant challenges to that approach resulting from provisions of the Maryland Public Information Act and the Law Enforcement Officers' Bill of Rights. And so it would be very difficult to establish an effective board with those state laws written the way that they are. And so at that time, I started looking in a different direction, which was working with continuing to work with NAACP and community advocates who were working on policing policy and working on creating a policing policy advisory board. So that conversation is coming along nicely, and we have draft legislation, and I'll be sharing that shortly. But in the meantime, I was really excited to see that there is continuing momentum at the state level to address some of the issues in state law that really have a big impact on our ability to do civilian oversight here at the county level. There may be, some of the distinct provisions, I think for us, maybe forest and trees here. I think the big picture is, we do need to see some change in state law. And I recommend that we do take a favorable position on this legislation. I would accept, some of the amendments that might be needed. I think that's sort of, again, forest and trees here. I think the important thing is we should be adding to the positive momentum to get something done. And there may be amendments that I would support, but I think what would be great is for Annapolis to hear that Montgomery County believes that this is an area that needs some change. And as you notice from the staff write-up, it's actually a case from Montgomery County that really clarifies a lot of these legal issues in the first place. So it's been an ongoing concern. So I know Councilmember Juando will have lots to say here as well as it pertains to his legislation. But you know, there's some important history as to why I think we should take this up now. So thank you.
Councilmember Juando.
Thank you, Council President. Thank you, Councilmember Reamer, for your support and work on these issues, and thank you all for presenting it. A couple things I wanted to note. My colleagues, and I was very happy when I introduced my first bill on Martin Luther King's birthday, all co-sponsored the Law Enforcement Trust and Transparency Act, which one of the main provisions, in addition to requiring independent investigations, also requires public reporting of said investigation consistent with Maryland law, right, to the extent allowed by Maryland law. And so that's the part that obviously is very relevant here, in that MPIA, as it's currently written, would pretty much lock up some of those at least big components of the report from being released potentially, if they are deemed to be personnel related. And so I would also suggest that we be in favor of this legislation at the state level. Eric Barron, Delegate Barron, the sponsor, and I go back a long way, and he's a very smart attorney, and we worked in the Senate together, and I've talked to him, and I think it's important for my colleagues to know that the ACLU of Maryland, the National Hispanic Law Enforcement Officers Association, the United Black Police Officers Association are in favor of this bill. And one thing that wasn't mentioned by our colleagues, my understanding is that there is a sponsor's amendment to limit the scope just to police and law enforcement. You can comment on that, but that's what I was told.
You know, we had heard that the sponsor was considering that, but we have not seen a formal amendment, and so can't speak to it directly, but we had heard that possibility.
As yesterday, I heard that was the case. Maybe it just hadn't been filed. I know they have a backlog of
Well, he may have it, but the first time that the public would know about it for sure is when he offers it at the public hearing.
right, which I think is tomorrow.
Yeah.
Yeah, so I know that, and I know there's going to be several of our constituents and down there for that purpose. So I would just again urge, part of the big part of that bill that I introduced, along with the independence, is the transparency. And I think if we're going to build trust with our law enforcement and continue to build upon that, we have a horrible case in the Eastern Shore of a young African-American male being killed, and questions of independence and transparency in that case are ongoing, and the state is now involved. I think we need to be on the side of transparency and public reporting. And again, as you noted, this is there is discretion, and I think there should be a presumption that we should disclose. I think that's where we want to be. And so I would just want to urge my colleagues to support it and just make them aware of the interaction with the bill that we are all co-sponsors on. Thank you.
Councilmember Glass.
Thank you, Madam President. I appreciate my two colleagues explaining why this is important to their legislation and towards the better good. But Councilmember Juando alluded to my question, which is, I understand us looking at this through the lens of police accountability, but what does it mean for the rest of the workforce? What about individuals who commit sexual harassment on the job or other improprieties? How would this facilitate public knowledge of those wrongdoings as well?
I'm going to answer that, and then Ed can jump in, but the way we read the bill is it applies to every complaint against employee misconduct. So it's not just limited to law enforcement at this stage, it's every complaint about employee misconduct, job-related employee misconduct.
Yep, that's correct. It would apply to all public employees.
Okay. Thank you for that.
Council Vice President Katz.
Thank you very much, Madam President. I certainly believe in transparency, and we all are co-sponsors of Councilmember Juando's bill for that reason, or one of those reasons. But my question is, how does this conflict at all with the Law Enforcement Officers' Bill of Rights? And if it does, who takes precedent?
I don't think it does, and let me separate out two things,
Okay.
because there was talk about the civilian review boards, and that's something different. There is a provision in the LEOBR, it was added 2 years ago, maybe, that allows for civilians to be on
Right.
the hearing boards. That is subject to collective bargaining under the LEOBR. Then there's another provision in the LEOBR that says it is not subject to binding arbitration unless authorized by local law. But that's about civilians being on the hearing board. This is about the availability of the investigation and the documents themselves, which are not otherwise available. I do not think this conflicts with the LEOBR. I guess if there was a question, there could be, somebody could propose a specific amendment to the LEOBR, but my reading of the case law, there was a case called Department of State Police versus Dashiell, where they said that the LEOBR, there's a provision in the LEOBR which confers confidentiality over IAD records, and they said that does not govern whether documents from an internal investigation are subject to disclosure to third parties under the MPIA. Because I had the exact same thought. I thought, oh, but I don't think that would be necessary.
And the whole idea that the Maryland Public Information Act, the MPIA, is similar to a civilian oversight board, is that correct?
Well, they're again, they're different things. The LEOBR provision is about whether civilians can be members voting or
Which
not.
we've agreed, Montgomery County's agreed with that, yeah.
Right, and now that is subject, the provision of the LEOBR that allows, and it gets complicated, there's traditional hearing boards and alternate hearing boards, and we tend to be using the alternate hearing board. That's collectively bargained. There's a representative chosen by the union, a representative chosen by management, and the neutral arbitrator. The LEOBR was amended a couple of years ago to provide that where you collectively bargain an alternative hearing board, which is what we've done, you can also collectively bargain to have up to 2 civilian voting members on that board. That's about, the presence of other people on the decision-making body who are going to decide whether to uphold the charges and what discipline will be imposed. It's not unrelated, but that's different than just the availability of the records. They're two different things.
And they're saying that some things could be withheld under an the MPIA. Who makes that call in this case?
The custodian. So the way we have, the way we do it here in Montgomery County is each department head is the custodian of that department's records. So it would be the police chief would be the custodian of those records. Kathleen mentioned before, and she's correct, there's a presumption of availability under the MPIA. The default setting, if you will, is that public records are available to the public. To withhold, even under a discretionary category, you'd have to show that disclosure would be contrary to the public interest. But that is subject to review by a court, whether or not a record should have been withheld or disclosed. But it would make them disclosable, whereas right now they are not at all disclosable. They're personnel records.
And if someone had brought charges against either, in this case, we're saying we believe it's going to be just the police, but we don't know that yet, obviously. But if someone had a complaint against a police or any other employee of the county, and that complaint was found to be, was not found to be correct, then under an MPIA, in this case, it would still be able to go forward? I mean, if somebody was, it's not fair that they were, someone complained about them, how does that work?
That's actually interesting. That was Shropshire's the name of the
Shropshire,
case that
okay.
made these IAD records considered personnel records. We thought they were investigatory records. Court said, no, they're personnel records, and you couldn't, in that case, give them to the Inspector General. One of the things the Shropshire court noted about not giving them was exactly what you talked about, saying that police officers could be, get complaints. These could be unfounded complaints. It would seem unfair that it would be made available to the public. Right now, this bill doesn't provide any further guidance about whether something's founded or unfounded. It simply says these kinds of records, being the complaint, an investigation, the disciplinary action, if any, that comes out of it, are discretionary denials. They're investigatory records, and using the general factors that apply to all investigatory records, the custodian will decide whether to release it. I guess you could have amendments that say, well, if it was found unfounded, then these are the other factors. There could be a reason the custodian might want to release, not just where it was founded and sustained, but maybe where something, the investigation clears an officer, but there's public clamor and they don't know, maybe there might be a public interest in releasing, saying, look, here, the investigation showed this was not, But it doesn't address that right now. It doesn't have that in there right now.
Okay. Thank you very much.
Councilmember Reamer?
Thanks. You mentioned the county executive had no position at this time. Did you discuss it with them and then they just decided no position, or hasn't
Yes.
reviewed it yet?
We did discuss it with him this morning, and he's taking no position.
Okay.
Okay. Councilmember Hooker?
Oh, thank you, Madam Chair. I think Councilmember Katz asked my two questions. I think we should, I think everything's been said, but I think we should support this with the stipulation that there will be the sponsor amendment limiting it to law enforcement.
Councilmember Albornoz?
Sorry, Councilmember Katz asked my two questions as well. And I do support in principle, particularly with the provision that it be directed to law enforcement. But I would also support adding language to the bill where there is a complaint made. There were situations that we had, as I was the director of a department, in which a complaint was made by the public that ended up being unfounded. And there was an investigation done to follow up on that issue. And I think to ensure the protection of the employee who had a complaint filed that was unfounded, that there be language in there ensuring that that information be out there in addition to the complaint being filed. So, but I agree with my colleagues in principle in terms of general support, but would support a provision for those two particular areas.
Okay. Councilmember Rice?
Thank you very much, Madam President. And just to shed a little bit more light on the MACO position, essentially the same concerns that were espoused here on this dais are the same ones that were there in MACO, which is the reason why it was opposed. There was a vague mention of it being shifted to law enforcement, but that wasn't before MACO at the time. And so with the concern of, again, what Councilmember Albornoz had said, that's really why folks were very concerned about actually putting this forward. And with its limited scope and with some of the protections in place, I think that MACO may have come up with a no position instead of a support. So again, I just wanted to kind of give you guys and reinforce the thinking that was there with MACO. And so while I had tried to push no position, there was resistance to that based on where we were currently. But I think that, either a no position or a support with those amendments would make sense. So.
Okay, so I think what I'm hearing the majority. Is something else you'd like to add before we vote?
Just quickly. I just wanted to say, in the interim here, thank you all for being verbose. Delegate Barron said he is planning to offer that amendment tomorrow at the hearing, so I can just confirm that for the benefit of my colleagues, the amendment that it would apply only to police.
We filibustered for you so you could get that information. I want you to know.
Trying to help you out there. I think I'm hearing the majority say that they support with the two amendments, the one with the law enforcement as well as some provision if there is unfounded situation where the allegation or the accusation is unfounded without objection. I think that's what we will do. Okay. Okay, next.
So the next bill is a tax bill and relates to federal tax reform from last year. Was of course a great deal of unknown. Also recall that Maryland is a SALT state. And so this piece of legislation introduced by Delegate Corman would waive the penalty, which is basically an interest penalty, for Maryland taxpayers who make estimated payments if they are under withheld and in violation of the two-part test that makes you under withheld. So it would waive the penalties for 2018 only. And the federal government also very recently acted to at least alter the criteria by which you have to adhere in order to not be subject to their penalty. So the county executive does support this piece of legislation.
This was on the news this morning on NPR. They did a whole story about this particular issue, so it's very much on people's minds. Councilmember Friedson.
Thanks. Yeah, I think just quickly, we get asked about this all the time, at least I do, and I think I can speak for everybody up here that we all get asked about this. Obviously, there's a lot of concern about what the implications have been and will continue to be with the federal tax changes, and notwithstanding, I think, the universal concern that many of us have, we're very limited in what we can do. This is one small way where I think we can push back a little bit and help our residents at least to mitigate some of the issues that are being faced and disproportionately going after taxpayers who live in places like this where we have high services and high expectations, and we pay for those services and for those expectations. And so I'm very supportive and appreciate the fact that we're taking this up.
I know that our council staff is recommending support. Any other discussion? So without objection, I think that we should support this bill.
Okay, and then before we get to a couple of additions on the agenda, we have an FYI bill for you, and it's the 2020 Census Complete Count Commission. It's a new piece of legislation that was filed. I'll let Kathleen talk about this one.
So as Bill mentioned, this bill, it would create a 2020 Census Complete Count Commission at the state level. So in talking with Diane Vu, who, with our Office of Community Partnerships, who's working with you and the other county leadership to lead the county's complete count effort, it's my understanding that there is no affirmative complete count coordination at the state level at this point. So we now have bills in on the House and Senate side to require that complete count effort be formalized at the state level. And it has a very expansive membership. There's 27 members that would be appointed. The purpose is very similar to the complete count effort here at the county level, to determine the state agencies that are able to support the census effort, to develop a plan for how each of those state agencies can support the effort, to develop a public awareness campaign, establish a public website, et cetera.
Okay. Councilmember Friedson.
Yeah, just really quickly, I'm very supportive of this, but I have mentioned before, and I would love if we could mention it to the bill sponsor. I haven't had a chance to do it personally, but adding aging adults as part of this. I think that our senior population sometimes can be hard to reach, and there's an increasing isolation challenge, and an area that I'm particularly interested in. I think I'm interested in all the areas that were mentioned here, but one that's often lost as we talk about complete count and hard to reach populations. Our seniors are frequently left out, and I think it's an important population, particularly in Montgomery County, that is aging at a significant rate, and that we should be focused on it just as much as we're focused on these other groups that are critically important to include.
We can definitely pass that on. I wanted to mention briefly that last year there was another bill that created a census grant panel. It's a $5 million statewide pot of money that's available for local matching grants. And so I know the county, again with Diane Vu's leadership, is going to participate in seeking part of that pot of money. Different than this, I just want to mention that. But we can certainly pass that on. I'll share with you that at the census grant panel meeting last Friday, the chairman of that group that's developing the guidelines for the grants said that two groups that are not recognized at the federal level formally for hard to count are under 5 and folks who don't have access to the internet.
Yeah.
Yeah.
Yeah, I was thinking about that group with respect to seniors particularly is,
Okay.
lack of access to internet even in our county, in our community. It's a challenge statewide, certainly, particularly in rural areas with limited access in general, but it's a challenge here too.
Sure, sure. Okay, we'll definitely pass that on.
And as we get into, in earnest into this work, it's going to be a very unique year. This particular census actually is going to be very unique because there is just so much mistrust out there in the community. There's the citizenship question out there as well. And for us, that's going to be a huge, huge challenge, because how do you actually, communicate to such a large immigrant community that they should participate and that everything will be just fine? That message, it's going to be very difficult for leadership and for advocates to send in terms of guarantees. And it would have a major impact on us, especially here in Montgomery County, because we know what the data shows in terms of our demographics. So this is going to be a unique challenge, and I know that all of us will be working together to figure out how to craft that message and what will the narrative be. But no doubt that I think this particular cycle will be a challenge for us. Okay, and so were you looking for a position on this? Is that, or
We put
just
it
an
on as an FYI if you'd
I mean, I
like to
think-
take a position
yeah,
on it,
I
you
think
may.
that all of
If
us,
you just
without
wanna leave
objection, we
it-
definitely do
She
support it.
took a census and we're good with it.
The census, everybody was okay, and there was no,
Aging adults.
Adding an
there was no undercounting or anything like that. All right.
It's a yes, but making sure it's fully inclusive.
Okay.
Okay, so we have a couple of additions. Late-breaking additions, Mr. Rice. I think the first one is, it's House Bill 396. I think you just received copies of it.
Does everybody have a copy of those? Amanda, those are the ones that I was referring to, but I don't think that's the copy that we got.
Well, that was from last time, right?
Because the one, yeah, Amanda, the one that you sent a copy was the SB 1188, but I was,
And we have emails about this one too, that you were involved in. It's all right, it's all right. We can be flexible, or, tell you what, we cannot. Do you know what the hearing date is on House Bill 396?
sure, I was just hoping that, we could have advanced copies for all my colleagues, because I just received this like 5 minutes before I got
Mr.
here.
Rice, you did,
Go ahead, Mr. Rice.
you did want House Bill 396 to be included? Okay.
Right, and the only reason why is because we don't have state ledge, and then next week, and then so we'll wait 2 weeks, and I wanted us to just weigh in on this, because it is very simple in terms of concept, and it's authorizing legislation, and so it authorizes the governing body of a county or municipal corporation to provide by law for an installment payment schedule of certain property tax due on real property. And so basically what it's doing is, because a lot of our elderly residents, some of our folks who are struggling, whether it's folks via government shutdown, whatever the case may be, are challenged with even the biannual payments, the idea of giving us the authority to be able to set up an installment plan for some folks, understanding that they may not have those lump sum large payments, but could pay in an installment, would be something that would afford us flexibility. And so this was brought up at MACO, and reason why I wanted to bring it up here, Delegate Carr is the lead sponsor of this bill, and I really appreciate him thinking about this in terms of what it is that we continue to see in terms of people who are struggling to pay their property taxes. I'm sorry?
396.
There, you would be able, it's HB 396, and you would be able to actually not charge interest on certain installment payments under certain circumstances. And the specifications are laid out in the bill, but it allows for us to basically set up that system. The interest payments, Sydney, just to give you an idea, it doesn't explicitly say what the exact restriction is on the interest. On what I see here, it said the interest may not exceed any discounts allowed by law. That's the limitation there.
All right, thank you. So I will just very quickly turn it over to somebody from finance. I think what we're going to do is do a polling on this one, because I had
Yeah.
hoped that everybody would have this ahead of time, but that wasn't the case. So let's just have a, discussion, and then we'll poll everybody. I know that, I think there were some issues in finance as well in terms of how this would affect our, the cash flow and things of that nature for the county. How would that specifically affect us?
Good afternoon. I'm Mike Covey. I am in the Department of Finance in the Division of Treasury. Treasury is actually the division within finance that bills and collects taxes for Montgomery County. Thank you for listening today. I we have a lot of things to say about this bill, but the first is, we weren't sure exactly what issue this was trying to resolve or fix. This bill talks about installment payments for advanced payments of taxes, which is actually a bill and a law that the county council passed on December 26th of 2017 in anticipation of the Tax Cuts and Jobs Act being implemented in January of 2018 and affecting many taxpayers in Montgomery County. When the county council implemented that bill or passed that bill, we implemented it the same day because it allowed people to prepay their 2018 taxes, which were the taxes that came out in July of 2018. We're technically still in levy year 2018 right now. And over 12,000 taxpayers attempted to prepay before January 1st, 2018. Over 9,000 actually did pay in advance between December 27th and December 31st. They paid $80 million worth of taxes before taxes were ever due. Taxes were due, of course, on September 30th of 2018. So this bill seems to affect people who are prepaying only, and people would actually start paying in January for taxes that are not even calculated until July 1st of this year. They could start paying January of 2019 for taxes paid or that come out and are billed on July 1st of 2019, and which aren't actually due until September 30th of 2019. So as a means of getting you some background, over 9,000 people prepaid for 2018, 6 did for 2019. When we were talking to people throughout the week where people were coming in, we had 1,800 people come in the last 3 days of, the last 3 work days of 2017 calendar year. I personally talked to dozens and dozens and dozens of them. We had emails from people asking questions after the fact. We had 2 people ask us if they could do installment plans. And every year we get 1 or 2 or 3 people who ask us about installment plans. So again, my first question is always, what are we trying to fix with this? I could see if it was a plan to people paying installments beginning in July when tax bills actually go out. And it may be beneficial for them to do that. But this allows people to pay well in advance of when anything is due. One of the other things I'd like to say is tax due dates are the same. They have been the same for many, many years. And I think most people are pretty good about planning. And they can start saving up in January and February and March and April throughout the year to pay that first installment and then the second installment, which is due December 31st. So I'm not sure how this actually helps people. The third thing I'd like to say is we talked to the people who own Munis, which is our tax system. Our tax system had a hard time dealing with the prepayments for 2018, and it will have a hard time in the future also if a lot of people choose to do this. That being said, we actually have asked them what it would cost to actually implement an installment system within the Munis property tax system when this bill came out. They still haven't given us an answer, but normally changes of this magnitude are tens of thousands of dollars to implement. So it would be a cost that way. Just for further background, the Department of Finance has about 50,000 MC311 contacts every year, of which MC311 handles the vast majority, and we handle about 5,000 of them. I would note that every time we have a billing event, and this would add 12 more billing events, or 8 more billing events, or 10 more billing events of the year, excuse me, we get a massive increase in the number of people asking questions about it. People are going to ask questions because they're not sure what's due next month. and they're not sure when they're going to get that reconciling bill that tells them exactly how much they're going to be paying for the rest of the year once we actually have a tax bill. One of the problems with our tax system is that because we don't have a tax bill until July, we can't accurately predict what a person's tax bill is going to be. It's usually roughly the same as the previous year with inflation or any changes in assessment that may have caused an increase or a decrease. But we can't give them an actual number until July. So we'll get a lot of questions about, oh, when's my payment due, and so on and so forth. So there'll be a lot more activity at MC311. That's my only, the only reason for saying that is it's going to have an impact on personnel costs also for 311 and us.
Has the executive taken a position on this at all?
Well, he did this morning, but he had not heard from the finance department, so I think we want to make sure that he's in, the finance department shares this information with them, and then we'll be back to you with what he thinks.
Councilmember Rice and then Council Vice President Katz.
Thank you, Madam President. So it's interesting that Finance takes a stance that this is about advance payment and only about payments on January 1st, when in fact the bill actually specifies that it gives an option of an installment payment schedule may include any of a number of due dates scheduled on or after January 1st and on or before the due date under this title or subtitle, whichever is applicable, and it talks about installment payments scheduled after July 1st. It gives us flexibility to do and structure it however we want. So a characterization to make it seem as though this is just solely for advance payments of those folks who are affluent, who had the ability to be able to pay a large check in advance, I find is a stark mischaracterization of how the bill is actually structured. As I said before, in terms of my description, I see this as the ability for us to structure this in a way that really gets at what is already in law codified for Prince George's, which allows for specifically seniors to be able to pay. And we can actually craft it in such a way that makes that the case, with this being enabling legislation that allows us as a locality to do what we want and set our regulations accordingly. Certainly we can set whatever restrictions finance deems necessary to alleviate a lot of the challenges that we face, but I certainly would hope that both the finance department understanding that I'm sure, and I'd like to get numbers as to how many of our constituents are challenged with paying their property taxes on time, since it seems as though it's not a challenge, when in fact I hear from residents all the time anecdotally about it being a challenge, is just stark, discrepancy in my eyes. We heard from so many people about the challenges that they faced when the tax code changed, and how people, not just are affluent, who are able to stroke tens of thousands of dollars in checks, and there was only one council member who had an issue with that at the time, and that was me. So I'm certainly not looking to give a handout for those affluent. I'm exactly the opposite, looking for us to give flexibility for those who don't have the ability to stroke a big, tens of thousands of dollar check. So from that perspective, Madam President, I think that the information that we got from Finance is not really in line with the true spirit of the bill.
Vice President Katz.
Thank you very much, Madam President. And certainly, I think everybody's in favor of trying to help people, and I'm sure Finance is too in this case. But if this were for current taxes, not for prepayment, if Ms. Govia, if this were for current taxes, not for just for prepayment, would you have an opinion on that?
I actually didn't express an opinion at all.
Or would you have, whatever, however you would say it?
Some
Yeah.
background. There are costs associated with it. That was all that I was saying about it. And honestly, the 10204.3, 10205 is the advance payment or prepayment section. That's the second section that's contemplated here. 10208, the meat of this, actually says in A2 that it's may be scheduled in advance of the property tax bill. So the way it's drafted, it makes it sound like that they are contemplating that we would allow people to pay in advance of receiving a tax bill. That's the only reason that I said it that way, because it says it in the bill that way.
Well, if it were changed that it could be both, I certainly wouldn't have any problem with it saying that. But right now, are prepayments in the federal tax code, and I know there was changes, but were prepayments allowed under the federal tax code to actually get a tax break over it?
Well, I can't really interpret federal tax code for you.
I don't think they can either, but anyhow, go ahead.
Well, let me just say this, based on the, because we don't work with federal tax code, what the IRS told the world on, I think it was December 27th of 2017, was that prepayments are eligible for deducting off their 2017 taxes if there was a bill when the prepayment was made.
Right.
So technically, there has to have been a bill as of December 31st of any year for it to be, for the taxes for that year to be deductible on that date.
And Montgomery County does not send out a bill prior to January or whatever, right? Wasn't that part of the issue?
Well, that's correct. We don't actually have the assessments for billing until June.
Till June.
So for the 2019 tax bill, which comes out in July, we get the assessments in June of 2019.
And there's a limit now to how much property tax someone can take anyhow.
Right, as Kathleen mentioned earlier, or Melanie, the SALT deductions, state and local tax deductions are limited to $10,000, so,
Thank you.
right.
Councilmember Friedson.
And there's I'm sorry, let me finish answering your question. There's still the issue of recoding the tax system in order to be able to manage installment payments within the tax system, that's all. And we just don't know how much that's gonna cost yet.
Okay.
All right.
Friedson.
Thank you, Madam President. Ms. Wanger, did you want to?
We have something to add about Maryland Association of Counties amendments, if we might,
Okay, so
Okay, well-
I'm just trying to make sure that,
unless you,
trying to manage this process, because obviously we didn't have this ahead of time, which is what we had asked to do in this long retreat that we had. So what I like to do is to get whatever council member questions there might be, and then we're just gonna poll everybody and whatever additional information you might have, because we can be here all day. And we're trying to establish a process so we don't have to do this. So if everybody just puts out their questions, and then if you guys can just send whatever additional information so we can then do a polling.
I really appreciate that. I think my broader point was going to be, I appreciate everything that Councilmember Rice and Katz said. I think that there, some interest here. I think in doing it, I think it would be helpful just from a process standpoint for us to be working a little bit more collaboratively to really understand what the goal is, how to do it, and to be working with finance, with the council, with Delegate Carr, who's back there, who I appreciate putting this forward, to be able to actually kind of understand this in a little bit more substantive way as the process. I did have a specific question about as part of the process from previously, and I certainly can appreciate how challenging tax systems can be and the costs associated with changes to that, having been on the staff side of a tax collection agency previously. But do we have data on the number of taxpayers in Montgomery County, property tax payers who pay through escrow, where their payments are coming from a mortgage company versus who are paying directly lump sum, since there are already people who are, basically prepaying. They're not prepaying us, they're paying as they go.
Yeah, about roughly 65% of property taxes are paid by mortgage lenders on behalf, so they're escrowed. Yeah.
It's different, but I think it speaks to a trend of interest in the way that people like to pay, as they go forward. Some of that is taxpayer driven, and some of that is mortgage company driven, and so it's not a perfect data point. I was just interested in that. The other thing, and this is just a broader question, you raised something earlier that was a little bit alarming to me, that you had a position from the county executive, but that the county executive hadn't talked to finance before you got that position. I just would be interested in you clarifying that for this particular bill, and also to understand if that is a common occurrence and whether it would make sense for us to get, or whether or not there's a need for us to get a position from the executive agency and from the executive, because, I mean, it would seem to me that the, it would seem to me that the agency, that the county, that the county executive, his position is based on the agency, and so it's a little bit confusing as to.
Appreciate that observation, and perhaps we can get clarification, but we're not gonna be able to do that. So, any, let's see, Councilmember Reamer, then we need to wrap it up, because we're gonna have committee sessions, whatever additional questions. Yeah, whatever clarification or questions that you're hearing, if you could please send it via email, so that we can get to a place. If you can forward that, that would be great, yeah. And, I mean, it's a good point that you raised, but, you know, I don't think it's fair to ask agents, particular departments to give us a position, and then the executive, hopefully you guys will be able to figure out. We have to go by what the executive says, so, you know.
I guess the larger question that I was asking is, previously, I had always assumed that the executive's position was based on the input from the agency. That was apparently not the case in this particular time, and I wanted to know whether or not that was a regular occurrence, or it just happened that this came in last minute and it was it's a process issue as opposed to a long-term issue.
I'd like to just speak to this point. No, this is an unusual piece of legislation, almost. I mean, it is very rare that, you know, we don't have the advice of this. But it came up as a discussion item, and he specifically said, but I'd like to hear from finance first. But yeah, he made an initial reaction, so. But it's not a final reaction, so.
Okay, we'll look forward to the final reaction. There is another bill, as an FYI, if you will, that I would like to be distributed to my colleagues, and then if there are any questions, if they can be sent over.
If you would, right, the capital park and planning bill that you have, that's kind of a handwritten in too, is in a similar posture. We can write something up and it can be pulled because.
No, we don't have any of these.
It's not a rush. The bill hearing on this bill will be when we have another shot to talk to you again later.
Okay, so if you can distribute that, you know, to my colleagues, so everybody can start thinking about it, and any questions that there might be, that'd be great. Okay, I think is that it?
Yeah, the small cells package, you have
The
that
small
for your
cells package,
information.
we do have that.
If you want to talk about it, that's fine, but otherwise, again, we can
Can wait for
let
next week.
people absorb that.
Digest this.
Talk about it later.
Yeah.
The information you
Okay.
gave, I'm sorry, the information you gave us was based on Senator Middleton's bill from last year. It's not,
No.
that's what we have here.
No, you have a packet of information.
Yep.
You received an email last night that
You did.
had three attachments. Two were detailed summaries of the two new proposals.
Right.
And also a position statement which reflects the county's opposition to the industry bill from last year. That industry bill from last year is very similar to the one this year, so that was just
Oh, I
a
see.
flavor of what's to come. And then also in that email, you had kind of basic, you know, more kind of 10,000-foot summaries of FCC ruling and the two proposals that are before you this year.
Okay.
Okay, Councilmember Reamer.
Thank you. I'm sure it will be fairly easy for the council to take a position on the two bills, the industry bill and the MACO bill. We will not be here next Monday because of the holiday, so the hearing is before we will meet again. So, but again, I think it'll be easy for folks to take positions. I think the broader challenge is navigating through this whole topic and preemption and the threat of preemption. And when the council did not move forward on a zoning code for residential zones, we, made ourselves quite vulnerable to preemption, in my opinion. And our existing code has a 300-foot setback from equipment, which, is not a secret. So it leaves us in a very weak position, I think, to fend off preemption. So we've got to really be on top of this and see how this goes and testify as needed.
Well, I think it's important also for the record to say that, we worked very hard on this issue, and obviously it's a very complicated, very controversial issue, and, we did the best we could to move forward with the commercial side. We understand that it was not a, perfect process, but it's not as if we on purpose decided not to, continue and finish up because we wanted to be preempted. I mean, obviously, there's just a lot of different perspectives out there. And so I mean, I don't disagree that we have to monitor this very closely, but, you know, a lot of work went into this. And so we will definitely do that. And we will make sure that, you know, we poll to make sure that we can get in there our position before it's taken up. Okay? All right. With that, I think we are adjourned. Thank you.